Welcome to Trial Site News Podcast Series. Today we'd like to introduce Kathryn Ardizzone. Now, she has an impressive background, currently working as counsel with Knowledge Ecology International, but also with a background in public interest and civil rights law. She has worked with prominent consumer rights groups, worked in prominent law firms, clerked for a judge in District of Columbia Superior Court with not only a law degree, but also a journalism degree from UNC. So Kathryn, welcome.
Thank you.
The pleasure is ours. Now, can you share a little bit of your personal story? Where did you grow up? How did you find your way to law school?
Sure. So I grew up in Warwick, Rhode Island, which is a suburb of Providence, and I had a very good public school education there. My teachers really encouraged me to love politics, government, and history. And at the encouragement of my junior high social studies teacher, I was a poll runner for the Bush v. Gore election. And then going into high school, there was 9/11 and the war in Iraq. So there was a lot going on in U.S. and international politics when I was growing up and entering into high school. And then the values that my family instilled in me were that whatever I do with my life, I should use my talents to the best of my ability to make society a better place and to help people. And so I knew that that's what I needed to do. I just didn't know how I was going to do that. And then I thought that journalism would be a good way for me to use my abilities to benefit people, and I would write for a newspaper. So I went to UNC Chapel Hill, which has an excellent journalism school, and student newspaper, thinking that's how I would make my contribution to society. But as I was graduating in 2009, it was a very bad year for newspapers. There were massive layoffs and people were questioning the future of newspapers as a viable business entity. So at the same time, I was taking some philosophy classes and really enjoyed that and felt like I had an affinity for logical reasoning. So I took the LSAT and thought maybe law school and a legal career was how I could use my abilities to benefit people and society in general. And I'm glad that I made that choice because I loved law school and I really enjoy my career as a lawyer.
Now, what got you interested and involved in public interest legal pursuits?
Like I said before, the values that my family instilled in me were to use my talents and abilities to the best of my ability to try to make society a better place. So for me, it felt clear that if I was going into the legal profession, I would go into public interest law. Also, I would add that before I went to law school, I worked for a big law firm, which is the kind of law firm that defends corporate interests pretty much. And I talked to a lot of the associate lawyers there, and they weren't happy. And they warned me, they tried to talk me out of going to law school in general, but they said if you do, you should really think about considering a career in public interest because they just weren't happy working in big law. And so that just reinforced the idea that if I'm going to do this, I really need to do public interest law.
So what about drug pricing then? What got you interested in that?
I was working for Essential Information, which was founded by Ralph Nader, and learning more and more about excessive drug prices and dramatic price increases. And at the same time, the president of Essential Information, John Richards, made me aware of a job opening at KEI, or Knowledge Ecology International, which has been working on these issues for the past 40 years. And I readily jumped at the chance to take the interview, and I was hired, and the rest is history.
Now, can you share your research and activist work in regards to U.S. investment in COVID-19?
So I started by looking at remdesivir, which is a repurposed COVID-19 drug, and whether or not the United States government contributed to its development, and I found that, in fact, it had. And so I wrote a report about that based on all the information that I could find that was publicly available. And what I found was that the U.S. government played a large role in refining the compound that's remdesivir and then developing it initially as a treatment for Ebola virus, but then U.S. scientists and scientists backed by United States grants investigated it against coronaviruses and found that it was effective against coronaviruses in monkeys. And so that really laid the groundwork for using remdesivir as a treatment against COVID-19. But then COVID-19 kind of presents a unique situation because we knew that funding agreements would be executed right now. So instead of being backwards looking and looking at what has already happened, we needed to be forward looking and look at the investments that the United States government is making right now for new COVID-19 technologies such as treatments and vaccines. What I realized was that in February of 2020, many of the agreements were already executed. So the Department of Health and Human Services would issue press releases announcing that it had entered into an agreement with companies like Johnson & Johnson or Regeneron to develop a COVID-19 treatment or vaccine. But in those press releases, it would say that it wasn't entering into a new traditional government contract. It was expanding on something called an other transaction agreement. So once I noticed this happening more than once, so a couple of times, I thought maybe this is a trend, and there's a reason that the government isn't just using standard government contracts, but is instead using this type of contracting vehicle called other transaction agreements. So what I found when I was researching other transaction agreements, that the agencies that have been given this authority by Congress to enter into other transaction agreements believe that the agreements are exempt from federal laws that prescribe a standard set of regulations that protect taxpayers in various ways. So when agencies are entering into other transaction agreements, they believe that they're starting with a blank slate, that it promotes true freedom of contract. They don't have to follow the Bayh-Dole Act. So the Bayh-Dole Act has its issues, but basically it can be thought of as a compromise. On the one hand, it allows recipients of federal funds that are conducting R&D to retain exclusive rights to any inventions that arise from the funded research. However, on the other hand, it protects the public because one of its stated purposes is to protect against unreasonable use of federally funded inventions. So it gives the government things like the royalty-free right to use an invention for government purposes, which could conceivably include ending the COVID-19 pandemic. It allows the government to march in if a contractor fails to make an invention available to the public on reasonable terms, and that includes price. So while the government is funding these inventions and the contractor is allowed to retain exclusive rights to the inventions, the government retains rights for itself, and those rights are intended to protect the public's investment. So the idea that these rights were exempt from other transaction agreements, and these other transaction agreements were awarding hundreds of millions of dollars to fund the development of badly needed COVID-19 vaccines and treatments, was very alarming to me. What I found was that they did, in fact, water down the government's rights in federally funded inventions for those agreements. But I needed to draw a connection to COVID-19 and see how these other transaction agreements were being used for COVID-19 R&D. So what I did was I submitted on behalf of KEI a Freedom of Information or FOIA request for the agreements that HHS was entering into for COVID-19 vaccines, treatments, and diagnostics. They came back and said, the request is too broad. It's going to take a long time to give you any records. So in late June, after much back and forth with HHS, I was able to obtain 6 contracts for COVID-19 that were entered into by HHS, awarding hundreds of millions of dollars. And what I found was that the majority of them were other transaction agreements that had been entered into by HHS prior to COVID-19, and then they were expanded after the onset of COVID-19 to encompass the development of a COVID-19 treatment or vaccine. And they did, in fact, as I had suspected and as I was concerned, the agreements did, in fact, water down the government's rights in R&D. So a lot of my advocacy and research this summer involved obtaining and analyzing these contracts and disseminating our findings to the public through a report and our contacts with the press. Another thing that I learned was very interesting after obtaining the contracts was that the agreement between HHS and Moderna involved a very interesting clause that said that in all press releases describing Moderna's vaccine candidate, Moderna was required to disclose information about how the development of Moderna's vaccine candidate was funded. Moderna was required to state the total contribution by the US government and then the proportionate contribution, as well as the contribution by non-governmental entities and their proportionate contribution. And at the same time that I discovered this, Zain Rizvi from Public Citizen discovered it as well. And we kind of came together and said that this is really an important provision because we're always advocating for transparency over how much the government is involved in funding R&D. to kind of counter the notion that drug development is so expensive that it always justifies high drug prices, because we need to compensate drug companies for their large investments. So we thought that this provision was very important. It was a contractually binding obligation, and Moderna was not complying with it in any of its press releases. So we wrote a letter to BARDA, and BARDA is a component of HHS, which is the Department of Health and Human Services. And we asked BARDA to look into the situation and investigate Moderna's apparent non-compliance. BARDA actually responded to us within a few days, so we were very grateful for that. And then shortly thereafter, a new Moderna press release describing its vaccine candidate admitted that BARDA was funding 100% of the development of its vaccine candidate, which is really important information. And the other part of my advocacy is, while we were successful in obtaining the COVID-19 contracts, the 6 agreements that I mentioned, they were heavily redacted. They did have the IP terms and data terms disclosed, which showed that the government was weakening its rights in the resulting IP and data. While the agreements gave us very valuable information, because the IP and data terms were mostly unredacted, and they did show us that the government was weakening its rights under the Bayh-Dole Act. So for example, under the Bayh-Dole Act, the government has the authority to march in if the contractor, so in this case, for example, Johnson & Johnson or Regeneron or Genentech, fails to achieve practical application. To know what that means, you have to look at the definition of practical application. And that involves failing to make a drug or other federally funded invention, such as the vaccine, available to the public on reasonable terms. And that includes being available to the public at a reasonable price. When we looked at these OTAs, they redefined practical application. So the contractor, which was receiving hundreds of millions of dollars to $1 billion of taxpayer funds, was no longer required to make the invention available to the public on reasonable terms. The contractor was only required to make the invention available to the public. So that is a significant weakening of the government's rights. In the Johnson & Johnson contract for Johnson & Johnson to develop a COVID-19 treatment, the government's royalty-free right to use the invention for government purposes was completely eliminated. So we did learn important things. We disseminated our findings to the public. We did make important findings from those contracts, but my work wasn't done because they were so heavily redacted that I needed to go through the administrative appeal process to hopefully demonstrate to HHS why those redactions were not lawful under the Freedom of Information Act. And we're still awaiting their analysis or their final determination on our appeal. Once we see what their final determination is, or if it takes too long and we're waiting for an excessive time period for a final determination, we may need to pursue litigation. To answer your question, a lot of my work this summer has involved these other transaction agreements, but we have a number of other FOIA requests that are pending, and it's a lot of back and forth, and then you need to file an administrative appeal and hopefully persuade the agency that its redactions or denial of your request was an error. And then the last resort is to file a lawsuit in court. And we've just recently filed a complaint against the NIH for its failure to respond to 3 of our FOIA requests within the time period prescribed by the statute.
Now to your point, there doesn't seem to be much contract transparency. What's your take on Operation Warp Speed?
So I think that your assessment is accurate, and there is not much transparency over the Operation Warp Speed contracts, and it's really concerning. So with COVID-19 and the government's response, you can think of the contracts as falling into 2 categories. There's the research and development contracts, and then there's the procurement contracts. In the procurement contracts, the government is making advanced purchases of hundreds of millions of doses of a vaccine. For the R&D contracts, those are the contracts that I was describing earlier, where the government is funding the development of a COVID-19 vaccine or treatment from its inception all the way through to FDA approval and some scaling up of manufacture. Those are the agreements that I obtained 6 of those agreements under the Freedom of Information Act. And while they did reveal some very important information, they were heavily redacted, and the redactions were puzzling. HHS redacted information under Exemption 4 of the FOIA, which protects confidential commercial information that's obtained from a party outside of the government. But the information that they redacted was clearly not confidential. In some instances, the contractor had revealed the information to its investors or the SEC in its SEC filings. So I'm not sure what its analysis was in performing the redactions, but it is 100% clear to me that many of the redactions were unlawful. So it was 100% clear to me that many of the redactions were unlawful. So that's one example of the non-transparency over Operation Warp Speed contracts. Another example is in the procurement contracts. And this example is even more egregious. So starting in, I think, late June or early July, the government began to announce that it had entered into purchase agreements. For example, in early July, the government announced that it had entered into a $1.6 billion purchase agreement with Novavax. So the HHS press release about the agreement said that the agreement was between Novavax, HHS, and the Department of Defense. So we thought it would be very important to have a copy of that agreement, and we submitted a Freedom of Information Act to both HHS and the Department of Defense. We still haven't heard anything back from our FOIA requests to HHS and DOD, but I was speaking with an NPR, I was corresponding with an NPR reporter named Sydney Lupkin, and she had submitted a FOIA request for the contracts as well. And she got a no records response from HHS stating that it maintained no records of the agreement between HHS, DOD, and Novavax. So we did a little digging, and what Sydney found was that Novavax doesn't actually have an agreement with the US government. It has an agreement with a company called Advanced Technology International. Now, Advanced Technology International is a consortium management firm on behalf of the Department of Defense in an effort to develop products for Department of Defense personnel. But in this instance, Advanced Technology International and the MCDC consortium are being used to purchase doses of COVID-19 vaccines for $1 billion to $2 billion purchase agreements. And the agreement that the US government has is another transaction agreement with Advanced Technology International. And Advanced Technology International, in turn, enters into these agreements with Novavax, Pfizer, I think Johnson & Johnson, and other companies to advance purchase the vaccines. So all this is to say that that adds an additional layer of complexity to whether or not a copy of the contracts can be obtained using the Freedom of Information Act. It would be stunning if the Department of Defense said that it didn't have a copy of the contracts, because that would be a huge dereliction of duty on behalf of the government. I mean, the contracts are so important because they inform what rights the government has retained to protect the public if there are shortages or price gouging. But technically, because the agreements are not entered into by the US government, but they're entered into by Advanced Technology International, it is possible, although unlikely, that the Department of Defense doesn't have a copy of them. So it remains to be seen, but HHS doesn't have a copy of the agreement, and HHS is playing such a crucial role in our Operation Warp Speed and funding COVID-19 technologies that it really is stunning. And I think it raises a lot of questions as to why HHS and DOD have chosen to use Advanced Technology International as an intermediary, and why didn't it just enter into the agreements itself? Now, that reporter that I mentioned from NPR, Sydney Lupkin, she contacted Advanced Technology International and asked them, why were you used in this manner? This seems outside of your scope. And they said something along the lines of, oh, well, we have the members in place in the infrastructure. But I would note that Novavax did not join the MCDC consortium until the summer. So that answer doesn't really alleviate my concerns. To sum up, there's a significant lack of transparency over Operation Warp Speed contracts, and I think that instead of requiring the public to pursue them using the Freedom of Information Act, the agencies that enter into these contracts should just publish them on their websites.
Now, we know that you were critical of some of the deal making. that the government could have probably secured better pricing deals. Do you have some insight on what you would like to share with the audience on this?
Well, to be clear, I don't know 100% for certain the terms that the US government has negotiated in these contracts, because the ones that I was able to obtain using the Freedom of Information Act were so redacted. But what I did learn from those agreements was that the US government had watered down its rights. There's no reason in this pandemic, which is a public health emergency, with the government providing massive amounts of money, billions of dollars, that it would limit its rights and its ability to protect the public from price gouging and other abuses. But what we found was that it had, in fact, done so. So what we know is concerning. What I would say is that the government's massive investments in this R&D give it considerable leverage to negotiate concessions on behalf of the public, and it should be doing so. It should be a responsible steward of the public's investment, or just a responsible investor in general. For example, with the Moderna vaccine, you would expect that the price that the government is paying to advance purchase Moderna's vaccine would reflect the government's investment. The fact that the government has paid for the cost of developing the vaccine through the initial discovery of the vaccine, the government has paid for the development of the vaccine from its discovery all the way through to its eventual FDA approval and scaling up of manufacture. You would think that the price that the government pays for the vaccine would reflect that enormous investment, effectively de-risking Moderna's investment in the vaccine candidate. I would also note that the vaccine was jointly developed by Moderna and the National Institutes of Health. But the price that taxpayers paid for the vaccine is higher than we are paying for the Pfizer vaccine. And Pfizer apparently, as far as I know, did not receive substantial US government investment in its vaccine candidate. As far as we know, and we should know more because these agencies should publish the funding agreements, the government is not obtaining concessions for its massive investment in these products.
Now, moving forward then, is there any recommendations you have for citizens that want to get involved in a transparency movement for COVID drug and vaccine prices?
Sure. I would definitely recommend that people engage with their local member of Congress and let them know that it is important for them to be aware of the terms of these funding agreements, because Congress can exert considerable pressure on agencies such as HHS and DoD that fund COVID-19 R&D to publish the agreements in a publicly accessible database. That would be the first thing that I would recommend. The next step would be to support CTAP, or the COVID-19 Technology Access Pool, which is being facilitated by the World Health Organization, and is a way that rights holders in COVID-19 technologies, such as treatments and vaccines, can voluntarily share or pool their IP, data, know-how, cell lines, basically everything that you need for another company to manufacture the vaccine or treatment or other important COVID-19 technology. The reason that this is important is because we know that there have been and will be shortages, and no one company has the manufacturing capacity to supply the world's needs. On top of that, you have the public health interests at stake and the global economy on the line. You have these massive investments by governments and charities effectively de-risking companies' investment. So the case for a company holding exclusive rights over a COVID-19 vaccine treatment or other technology is very low. Those exclusive rights would prevent another qualified manufacturer from making additional doses of the vaccine or treatment as necessary. And the case for sharing is as high as you could ever imagine. So I think it would be very helpful to support the CTAP initiative. The World Health Organization Global Observatory on Health R&D maintains a database of clinical trial funding for COVID-19, the funding agreements, and any licenses to IP, data, know-how, and licenses to any IP, data, know-how, cell lines, or other important aspects of technology transfer in an online database that's accessible to the public. So I would recommend supporting that initiative as well.
Now, any final thoughts on drug prices and how Americans can participate in making them more reasonable?
It is a good thing for Congress to conduct oversight over pharmaceutical companies, and it should also conduct oversight over the federal agencies that fund biomedical R&D. Because unlike pharmaceutical companies, these agencies are funded by the American public and they are accountable to the American public. So I think that they have a duty to use the existing legal tools that they have right now to intervene when drug prices are excessive. They can exercise margin rights. They can use the government's royalty-free rights and inventions. And instead of doing that, they're actually using this loophole to weaken those rights. I think that there should be real congressional oversight with some follow-up. But members of the public should understand that these rights do exist and agencies are failing to implement them. So the pharmaceutical companies are not the only wrongdoers in this situation. Knowledge Ecology International is going to be hosting a monthly transparency meeting, which is going to be an informal discussion about all transparency issues, including but not limited to biomedical R&D, the lack of transparency, for example, over clinical trial costs. And all members of the public are welcome to attend, anybody who's interested in transparency issues. It's really going to bring together a lot of diverse strands of people. The first meeting will be on October 13th, and you can contact me for more information if you'd like to attend.
And what would be a good place or a good way to contact you?
You can email me at kathryn.ardizzone@keionline.org or visit our website at keionline.org.
Excellent. Well, thank you so much for joining us today. We really appreciate your time. We know you're busy, and we're glad you could make it today.
All right. Thank you for inviting me on, and I'm happy to come back anytime.
The pleasure is ours. Thank you.